All right, and I've just touched the live screen to start streaming this for the competition. So it looks like we are, all right, and I've just touched the live screen to start streaming this for the competition. So, and it's working. All right, so we are now live on the internet with friends and family watching. The next order of business is that anyone in the gallery who's not competing, please make sure that you're muted and that you're off video. I don't allow recesses today. We're going to get through this fairly quickly and efficiently. If there are any disputes, teams, coaches will need to report those disputes according to the rules. Please mind your time. Remember that it's time per side, not time per witness. And at this point, I'm going to go ahead and swear the participants in. So team members, please go on screen and raise your right hands. Perfect. Team members, please raise your right hands. Do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
Everyone, yes?
Yes.
Perfect.
Yes, Your Honor.
Now, if you go off screen and let's have our witnesses show up.
Oh, you guys, yeah.
Sorry.
It's okay. Witnesses, do you promise the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material, facts, or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? I need a yes.
Yes.
All right. Are there any gallery members, including teachers or attorney coaches that are here? Attorneys, please, and coaches, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Perfect. Now I need to swear in my scoring panelists, so if they can video on. Okay, scoring panelists, please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes. I do. Yes.
Perfect. Well, let us begin. Are there any preliminary matters for me?
Yes, Your Honor. May I begin?
Yes, please.
We ask that the time be stopped in case of any technical difficulties.
Absolutely, granted.
Thank you. We also have stipulations and trial rosters to share with the bench and jury.
All right.
And exhibits have been previously shared with opposing counsel, but we are still going to ask that the record reflect we are sharing with them again when we move to have exhibits examined for identification purposes.
Absolutely, that's great. Thank you.
And finally, we ask that even though this is a virtual tournament, the court allows the exhibits, once admitted into evidence, be left on the witness stand so they may refer to the exhibits throughout their testimony.
Absolutely, granted.
Thank you.
Anything further for the prosecution?
No, Your Honor.
Defense counsel, do you have any preliminary matters for me today?
Yes, Your Honor. First,
Go ahead.
first, we would like to clarify that pursuant to Rule of Competition 7.4, for the purposes of our online competition, exhibits that are displayed on screen will not be shown to the jury unless we specifically request to publish. Exhibits may be shared on screen for purposes of identification prior to admission.
That is the procedure I prefer. Thank you, counsel. Granted.
Additionally, Your Honor, while each of our attorneys and witnesses have made efforts to be in a setting with the best internet capabilities possible, if at any point the court cannot see or hear us, you should feel free to interrupt us at any time.
We'll work together on all of those issues, and we'll give each other leeway because technology is difficult
Yeah.
some days. All right, granted. Good idea.
Your Honor, for the record, all witnesses will be present for trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
That's correct. Under the rules, there's no witness sequestration. Thank you.
We would also like to request that stipulations and jury instructions be constructively read into the record.
Granted.
At this time, Your Honor, may we introduce ourselves?
Yes, please.
Good morning, Your Honor. My name is Max Seitel. I'm an attorney for the defense. I will be presenting the opening statement. I will be conducting the cross-examination of Kyle Kuzak and the direct examination of Blake Van Allen.
Good morning, Your Honor. My name is Hayden Clausen, and I will be conducting the cross-examination of Alex Cifuentes and the direct examination of Taylor Perkins.
Good morning.
Good morning, Your Honor. My name is Marcus Winton, and I will be conducting the cross-examination of Detective Jordan Markowitz, as well as the direct examination of Miss Avery Becker. I will also be presenting the closing argument. May our witnesses now introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Brandy Mallender, and I am Taylor Perkins.
Good morning.
Good morning, Your Honor. My name is Paige Funchy, and I am Blake Van Owen.
Good morning.
Good morning, Your Honor. My name is MJ Mintz, and I am Avery Becker.
Good morning. Does that complete the defense team?
Yes, Your Honor.
Great. May we have introductions from the prosecution?
Yes, Your Honor. Good morning, Your Honor. Opposing counsel, ladies and gentlemen of the jury. My name is Dylan Pearson. I will be conducting the opening statement, the direct examination of Alex Cifuentes, and the cross-examination of Avery Becker.
Thank you. Good morning.
Good morning, Your Honor. I'm Rosie Gonzalez, and I will be doing the direct of Kyle Kuzak and the cross-examination of Taylor Perkins.
Good morning.
Good morning, Your Honor. Ladies and gentlemen of the jury, my name is Eiley Rubio, and I will be conducting the direct examination of Jordan Markowitz, the cross-examination of Blake Van Owen, and the closing argument.
Thank you. Good morning.
May our witnesses now introduce themselves?
Yes, please.
My name is Tyler Bovert, and I'll be playing as Kyle Kuzak.
Good morning.
My name is Emily Gonzalez, and I'll be playing Alex Fuentes.
Good morning.
Good morning.
My name is Julian Ingle Lewis, and I will be playing Detective Jordan Markowitz.
Good morning.
Good morning.
Are there any other further introductions today?
No, Your Honor.
Are we ready for opening statement from the prosecution?
Yes, Your Honor. May it please the court?
Proceed.
Your Honor, opposing counsel, ladies and gentlemen of the jury. In the words of Juvenal, revenge is always the weak pleasure of a little and narrow mind. And during today's trial, you will see this exact behavior in Avery Becker. The death of Mackenzie Brackman was no mere accident. His death was a result of Avery Becker's anger that has been building up for years. Mackenzie Brackman was a lawyer who devoted the majority of his time and efforts into teaching the young adults of Colorado High School the way of the law. His expectations were high, and he left no room to mess around on his team. This didn't sit well with Avery Becker, for she believed she was the best on the team and therefore didn't need to put in any effort into her work. When Mr. Brackman noticed this lack of effort on Avery's behalf, he knew she was not A-team material and demoted her to B-team. This enraged Avery Becker, causing her to manipulate her friend Taylor Perkins into quitting the team only so she could have things go her way. And after a reckless performance at regionals, Mr. Brackman knew he couldn't let Avery ruin their team's chances at winning state. And when he tried to explain to her she shouldn't have confused good showmanship with good lawyering, she stormed out, enraged and wanting revenge. She took out her anger on Mr. Brackman by writing Worst Attorney Award in permanent marker on the hood of Brackman's vintage 1986 Porsche 11, which ruined the paint. Her actions only added fuel to the fire and resulted in her being kicked off the mock trial team entirely. After many desperate attempts to get back on the team, she snapped. And when Mr. Brackman refused to speak to Avery Becker, she had already planned her revenge. Ladies and gentlemen of the jury, we are here today because Avery Becker is being accused of second-degree burglary of dwelling and murder in the first degree. What does this mean to you? This means Avery Becker intentionally and unlawfully broke into Mackenzie Brackman's home with the objective to commit second-degree burglary, and in the course of action, stabbed Mackenzie Brackman, causing him to bleed to death. We, the prosecution, have the burden of proof, which means we must prove every element beyond a reasonable doubt. Today, we will provide you with evidence that proves on March 6, 2020, in Denver County, Avery Becker broke into Mackenzie Brackman's home with the objective to vandalize it, and in the process, stab Mackenzie Brackman, which has escalated this to not just second-degree burglary of a dwelling, but murder in the first degree. Today, you will see text messages between Alex Cifuentes and Avery Becker, which state Avery Becker intended on going to Mr. Brackman's house to get her revenge. We will provide you with cell tower data which proves Avery Becker was at Mackenzie Brackman's house the day of March 6th. And finally, you will hear from two experts in their field that have both come to the same conclusion. Based off all the evidence they've collected and a careful analysis of the evidence, they have both come to the conclusion that Avery Becker did in fact murder Mackenzie Brackman. As we've already discussed, we, the prosecution, have the burden of proof, which means we must prove every element beyond a reasonable doubt. Today, we will prove Avery Becker wanted her revenge on the man she believed ruined her mock trial career. We will prove she showed up at his house and in the end, killed Mackenzie Brackman. We ask that you, the jury, are mindful of the fact that Avery Becker knows what criminal law is and has spent plenty of time in the courtroom and can work the law to her own advantage. It is your right as a jury to believe all, some, or none of a witness's testimony. At the end of this trial, my co-counsel, Eiley Rubio, will deliver the closing argument. The judge will then read you the law, and while he reads you the law, he will explain that direct evidence and circumstantial evidence are given the same weight, and both are acceptable in a court of law. Direct evidence being something you see, and circumstantial evidence being evidence that points to the same conclusion. At the end of this trial, you will see we have met our burden, and we ask you return a verdict saying Avery Becker is guilty of second-degree burglary of a dwelling and murder in the first degree. Thank you.
Thank you, counsel. I need to ask one question, and maybe one of you can help me before we proceed with defendant's statements. How do I turn off people who are not on video? All right, well.
Your Honor, if I may.
Yes, please, Ms. Van Owen.
If you go to the top right corner of your screen, there should be a little tab that says settings. If you click on that, there is a video tab in there and it has the option to hide non-video participants.
Okay, I will try to find that. Thank you so much.
It's no trouble, Your Honor.
All right, may we proceed with the defense argument? Opening statement.
Yes, Your Honor. Before I begin, can you hear and see me clearly?
Yes, sir.
Okay, good. May it please the court. There is no evidence. The prosecution has no evidence that links Avery Becker to this case. And because of this, a young woman's future is at stake, and a killer may get away. We can't change the past and bring the victim back to life, but we can bring justice into this courtroom today. On March 6th, 2020, mock trial coach Mackenzie Brackman was found dead in his home. He had been stabbed and murdered. We agree with the prosecution about these irrefutable facts, but beyond that, the prosecution will tell a story based on a rushed investigation that contains no evidence linking Avery Becker to this crime. But you will hear the truth. You will hear it from Taylor Perkins, a close friend of Avery Becker's, that the day before the murder, they were at the local fry shack playing games on their phones. Taylor Perkins will tell you that fellow mock trial teammate Alex Cifuentes could have taken the phone. Then the next day, when Avery Becker realized she lost her phone, she and Taylor Perkins spent the day looking for it, not breaking into someone's house. Next, you will hear from private investigator Blake Van Owen about how the prosecution rushed their case and how they didn't have any evidence linking Avery Becker to the crime. Blake Van Owen will go through the specifics of the crime scene, including the reconstruction of the stabbing and break-in, proving that the prosecution's crime scene reconstruction was inaccurate. Van Owen will also go through in-depth cell tower data that backs up the alibi provided by Avery Becker. And finally, you will hear from Avery Becker herself about her relationship with Mackenzie Brackman. Mackenzie Brackman had kicked her off the mock trial team, and all Avery Becker wanted to do was reconcile and get back on the team. She would never commit such a violent and heinous crime that she's been accused of. All three of these witnesses will discuss Blair Rollins, another suspect in today's case, who was barely investigated by the prosecution. Blair Rollins had a similar build to that of the figure seen in the Ring video cameras, and Rollins also had a clear motive to commit this crime. These witnesses will explain that Alex Cifuentes could have used the help of Blair Rollins to steal Avery Becker's phone and frame her for the murder. But the prosecution rushed their case, and they weren't willing to look into all the evidence that was actually substantial. I'm asking you to look for all the discrepancies in the prosecution's case, to look for all the holes that were filled with hasty and rushed interpretations of a case that doesn't have any evidence linking Avery Becker to this crime. You will see that neither of the prosecution's experts ever mention working with each other in their affidavits, and they even have some contradicting data. Detective Jordan Markowitz accepted unverified screenshots of possibly fake text messages and has even brought them into court today. Crime scene reconstructionist Kyle Kuzak has lost track of key photos for their investigation. I'm certain that by the end of today, you will see how the prosecution rushed their case and that it shouldn't be taken seriously in any sense. There is simply no evidence linking Avery Becker to the crime. Today, the prosecution holds the burden of proof. This means that to pass a guilty verdict, you, the jury, cannot hesitate in your decision that Avery Becker is in fact guilty. But I believe that you are all just and reasonable people, and that by the end of today's case, you will see the prosecution simply has no evidence linking Avery Becker to the crime. I believe that you won't hesitate to call for the innocence of Avery Becker. It is in your hands to make the right verdict. Not guilty. Thank you.
Thank you, counsel. Counsel for the prosecution, who will be your first witness?
Your Honor, we call Kyle Kuzak to the stand.
Please, sir.
Your Honor, may I begin?
Yes, ma'am.
Good afternoon. Could you please state your full name and spell the last for the record?
My name is Kyle Kuzak. My last name is spelled Kuzak.
Mr. Kuzak, what do you do for a living?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator.
And could you tell me what a crime scene investigator does?
He investigates home invasions, burglaries, and other property crimes, homicides, domestic violence, armed robberies, and just any crime really.
And how long have you been doing this for?
I've been doing this for around 19 years at the time of writing my affidavit.
And who do you work with?
I work with the Denver Police Department.
So does this mean that you are a police officer?
No, I'm not a police officer. I am a civilian employee of the Denver Police Department.
And can you tell us what kind of cases you worked in?
I've worked in all cases from home invasions to homicides.
Your Honor, I now move to admit Kyle Kuzak as an expert witness in the area of general crime scene investigation, complex crime scene investigation, and crime scene reconstruction.
Any objection?
Yes, Your Honor. I object to lack of foundation. I would like the witness to explain further their experience and education in crime scene reconstruction.
Counsel?
Your Honor, may I respond?
Yes.
Your Honor, pursuant to Rule 702, an expert witness must have education, training, or experience. Today, my witness has shown that he has training and education, or training and experience in this area.
Counsel Gonzalez, what is his training and experience?
He has been working for 19 years in crime scene investigation. And he has been working with the Denver Police Department.
Thank you. The court will recognize Kyle Kuzak as an expert in general crime scene investigation, complex crime scene investigation, and I didn't get the last one down, crime scene reconstruction.
Yes, Your Honor.
All right. If I didn't get that right, tell me now.
No, you got it right, Your Honor.
Okay, thank you. Mr. Kuzak and counsel, please proceed.
Mr. Kuzak, can you tell us more about how you complete an investigation?
I have a 5-step process, which could follow the same steps as even baking a cake. First, you would open the cookbook and you would find what ingredients you would need. Then you would write it down, take it to the store, and collect all of your ingredients or otherwise evidence. And once you have all your evidence, take all your ingredients, take it home, put it all together, make sure you have all the right portions, all the right ingredients, mix it all together, bake the cake and eat it. And finally, you would just go tell your mom how great you did on your cake.
Mr. Kuzak, how well does this process help you in a case?
It works as long as I can get all the way through with it. It should work almost guaranteed. It follows the same process as a scientific method. So,
Your Honor, let the record reflect that I am showing opposing counsel Exhibit 17.
So the record will reflect.
And just one moment as we are having some technical difficulties.
I see Exhibit 17 perfectly. Thank you.
Mr. Kuzak, can you tell me what this is?
this is my witness tracking sheet.
Do you keep this document in your regular course of business?
Yes.
And is this document updated regularly?
Yes.
Is this an accurate depiction of your witness tracking spreadsheet for that day?
Yes, it is.
And are you the keeper of this record?
Yes.
Your Honor, I now move for the admission of Exhibit 17 into evidence.
Any objection?
No objection, Your Honor.
So admitted. Exhibit 17 is in the record.
Your Honor, may I proceed?
Yes, please.
Mr. Kuzak, do you have any suspects on your chart?
I have 3 suspects: Avery Becker, Alex Cifuentes, and Blair Rollins.
Can you tell me why Alex is the suspect in this case?
Alex Cifuentes was a mock trial member who was coached by Mr. Brackman and has already had some conflicts with Mr. Brackman, and is also had screenshots. Wait, what was it? Screenshots and messages.
Mr. Kuzak, can you tell me why Avery is a suspect in this case?
Avery Becker was also a member of the mock trial team, and she also had more history with Mr. Brackman, drawing on his vintage Porsche, and has threatened to do more property crime.
And can you tell me why Blair Rollins is a suspect?
Mr. Brackman was their defense attorney, and in their words, he did poorly as a defense attorney, and whenever he was Blair Rollins' father was convicted, they threatened to kill Mr. Brackman.
Mr. Kuzak, who is your top suspect in this case?
Avery Becker.
And why is Avery your top suspect?
Because after my 5-step process, all of the evidence that I've looked through has pointed directly to Avery Becker.
So with all your expertise, can you tell me what your professional conclusion of this case is?
Avery Becker had the intentions to go to Mr. Brackman's house to commit more property damage because he was mad about the car. So imagine how mad he would be after what she does to the house. And so she didn't expect Mr. Brackman to be there. They came into contact, and Avery Becker killed him.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor.
Proceed.
Hello, Mr. Kuzak. You claim that at the beginning of the crime, Mr. Brackman was, in fact, aware of the intruder.
Yes, I do.
And that he was alerted by his Ring camera system.
Yes.
But we can agree that the Ring camera system has push notifications that could have been turned off.
Yes, but I would see no reason for anyone to do that.
Objection, Your Honor. Assumes facts not in evidence. He is talking about Ring camera videos that have yet to be admitted as evidence.
This is cross-examination. The trier of fact can put it all together at the end of the case. Overruled.
May I proceed?
Yes.
But Mr. Kuzak, you never checked if the Ring camera notifications, push notifications, were turned on or off.
No, I did not.
Moving on, you suggest that during this crime, there was a struggle in which Mr. Brackman took out a knife and the intruder gained the knife from Mr. Brackman and used it to kill him. Yes? I'm sorry, can you repeat your answer?
I said yes.
But you have barely any evidence as to this struggle.
There are multiple scuff marks in the building, and a broken plate shows, I would say, that's some signs of struggle.
Let's talk about those scuff marks. You were never able to date when the scuff marks were made.
No, I was not.
And you were never able to find any concrete evidence as to how they were made.
No.
Your Honor, at this time, I ask that my trial technician display Exhibit 9 for purposes of identification.
Exhibit 9, please, for purposes of identification. Exhibit 9 is properly displayed.
Mr. Kuzak, you recognize this photo, right? As the broken plate? Is this photo fair and accurate to the best of your knowledge?
Yes.
Your Honor, at this time, I would like to admit Exhibit 9 into evidence.
Any objection?
No, Your Honor.
Exhibit 9 will be admitted.
Mr. Kuzak, we can agree that there is a broken plate in this photo, yes?
Yes.
But we can also agree that everything else in the photo, the carpet, the chair, the napkin, and the placemat, are all in order, yes?
Yes.
But you never investigated any other possibilities as to how the plate was broken. You just immediately assumed that it was broken in a struggle.
Well, as the open drawer was, they left an open drawer open. It seemed very rushed. So yeah.
Moving on. Your Honor, may my trial technician now display Exhibit 17, which has previously been admitted into evidence?
Correct. Exhibit 17 is in evidence. Please allow that to be shown to the trier of fact.
Thank you.
Exhibit 17 is before us.
Mr. Kuzak, in this exhibit, you mentioned three suspects, correct?
Correct.
But only one of them, Avery Becker, was mentioned as a suspect in your affidavit.
No, I never mentioned any suspect in my affidavit.
You are saying that you never mentioned any suspects, including Avery Becker, in your affidavit.
Yes.
Your Honor, may I take a second to pull up Mr. Kuzak's affidavit?
Yes, sir.
Your Honor, we would like to ask for what purpose opposing counsel is bringing up this witness's affidavit.
Your Honor, I am bringing up Kyle Kuzak's affidavit to verify certain statements and for purposes of impeachment.
Is it frozen?
Mr. Kuzak, in your affidavit, you say, quote, the potential fallibility of witness evidence does not diminish the need to organize and account for it in my analysis. However,
Yes.
you do not mention the suspects that you mentioned in your Exhibit 17, which is your own witness tracking spreadsheet.
Yes.
Objection, compound question.
Overruled.
And in Exhibit 17, you mentioned one Blair Rollins as a suspect in today's case.
Yes, I did.
But do you know where Blair Rollins is now?
No, I do not.
Do you know if you or the police have ever looked into the current whereabouts of Blair Rollins?
No, I do not.
Moving on, you say that you factored in the size of your defendants to your crime scene reconstruction of the defendant, like the intruder and the victim, into your crime scene reconstruction.
Yes.
However, you never mentioned any specific heights in your affidavit.
No, I did not.
And you've never seen Miss Becker in person, and you've never received any photographs from the police to compare her to the intruder.
No, I'm not.
Can you repeat your answer?
Yes, I have.
You have received photographs from the police of Avery Becker.
No, I've seen Avery Becker.
You have seen Avery Becker before.
Yes.
You never mentioned this in your affidavit.
I saw no need to.
Moving on. But in your affidavit, so you compared the size of the intruder and the victim, but you never factored in their sizes into your reconstruction of the stabbing.
Avery Becker and the Avery Becker and the person in the video both have the same size build.
But you never factored this into your reconstruction of the stabbing.
No, I did not.
Moving on, there was some blood splatter at the scene, yes?
Yes.
And this blood splatter was important to your case.
Mm-hmm. Yes.
And there were some photographs of this blood splatter.
Yes, there was.
But these photographs are not in court today, correct?
No, the data was corrupted.
So you were the only one who was able to see these photographs?
No, I was not.
But the defense expert had no access to these photographs.
I was not the original person who even took the photographs, so I was not the only person who had access to them.
But the defense expert has no access to these photographs.
Correct.
And the jury will not be able to see these photographs.
Correct.
Thank you, Mr. Kuzak. No further questions.
Redirect.
No, Your Honor.
Who will the prosecution call as their second witness?
Your Honor, the prosecution calls Alex Cifuentes to the stand. May I inquire for how much time I have remaining?
Yes. Defense
Sorry,
has,
it's 20 minutes and 48 seconds.
thank you. Please proceed.
Thank you, Your Honor. Good morning. Can you please state your name and spell your last name for the record?
My name is Alex Cifuentes. That is Sifuentes.
Ms. Cifuentes, are you currently attending school?
Yes.
Where?
I'm a senior at Colorado High School.
And do you participate in any extracurricular activities?
I do. I am in mock trial.
Ms. Cifuentes, what is mock trial?
Mock trial is a stimulated court case where we go through the motions of an actual trial.
And do you know who Avery Becker is?
Avery Becker is my best friend. I met her on mock trial.
And what's it like being on a team with Avery Becker?
Being on a team with Avery Becker is very difficult. She never comes prepared. She does not often have anything written out, and she does not study.
And has her behavior ever affected the team before?
Yes, it has affected our team before.
How so? Can you give us an example?
An example would be before regionals, she got into an argument with our coach, Mackenzie Brackman, and that caused her to be demoted off A team and onto B team. And then actually right before state, she manipulated Taylor Perkins into quitting the team so she could go back onto A team. And they had Coach and Mackenzie, Coach and Avery had another argument where Avery was enraged and went out to his vintage Porsche and wrote worst attorney and permanent marker, which caused her to be kicked off the team.
Objection, Your Honor.
Basis?
May be heard.
Yes.
Your Honor, I object hearsay pursuant to Rule 801 for the statement Best Attorney Award or Worst Attorney Award, excuse me, that was written on the car.
Counsel, response?
I'm sorry, Your Honor, can I ask the opposing counsel restates their objection? It cut out.
My objection was pursuant to Rule 801 hearsay to the statement written on the car, Worst Attorney Award.
Your Honor, might I respond?
Yes.
Pursuant to Rule 801, hearsay is an out-of-court statement being used to prove the truth of the matter asserted. This is not going to the truth of the matter asserted. This is going to the effect upon the listener.
It's not being used for the truth of the matter that the coach is the worst coach. It's just being offered for the purpose of showing that the conduct. So the statement itself is not hearsay for when it's used in this fashion. So overruled, but very good use of the rules. Thank you.
Thank you, Your Honor. May I continue?
Yes.
Ms. Cifuentes, did you ever speak to Avery Becker after that?
Yes, we had ran into each other at the Fry Shack later that night.
And what happened at the Fry Shack?
When I had ran into her, she and I had talked, and I gave her some advice on how to move on from this drama that had happened on the team and how to not let herself get caught up on it. And she was thankful and let me play games on her phone, actually.
And did you ever hear from Ms. Becker again?
Yes, we actually had a text conversation.
Your Honor, let the record reflect I previously shared Exhibits 14 with opposing counsel.
Record also reflect.
May I share Exhibit 14 for identification purposes?
Yes, please proceed.
Thank you. Ms. Cifuentes, can you tell me what this is?
This is a text conversation between me and Avery Becker.
And how do you know this?
I provided the detective with these, and it also says Avery Becker as the contact name.
And are these an accurate depiction of the messages you received from Ms. Becker?
Yes.
Your Honor, I now move to have Exhibit 14 admitted into evidence.
Counsel, any objection?
Yes, Your Honor. I have multiple objections to this. May I proceed?
Let me get out my paper and pencil then. Please proceed.
Yes, Your Honor. My first objection is pursuant to Rule 801 hearsay to both the messages itself and the contact name at the top. My second objection is pursuant to Rule 1002 best evidence, as this is not the text messages from the phone themselves, but rather a printout. Leading into that, I also object admissibility of duplicates pursuant to Rule 1003, as there has been a genuine question raised by the defense about the authenticity of these messages pursuant to Rule 901, which makes them henceforth inadmissible.
Your Honor, may I respond?
Yeah, let's take them in this order. The first objection is really to the authenticity of the document. Let's have a response to that.
Your Honor, the witness has previously testified that these exhibits came from Avery Becker and even has her contact name. So it's at the best of her knowledge that Avery Becker sent her these messages.
Anything further? Counsel for the prosecution, anything further to lay your foundation for this?
No, Your Honor.
14. All right, so that deals with authenticity. Let's deal with the 1002 best evidence rule. Counsel for the prosecution, what's your response?
Yes, Your Honor. The witness has already said that this was the best that they can provide, and the detective also accepted this.
Is the phone available?
The original copy is unavailable, yes.
Is the telephone available?
No, it is not.
Okay. I'm going to overrule the objections on the basis of 1002 and 1003, and as to hearsay, you have an objection pending to the substance of the text and also the name of the Avery Becker at the top. Let's deal with the name at the top.
Yes, Your Honor. Pursuant to Rule 802, hearsay exception, this is admission by party opponent. And the witness has previously testified that these were from Avery Becker.
Response from the defense?
Your Honor, even though Ms. Cifuentes has previously testified that these were from Avery Becker, the issue is the defense has called a, the defense is questioning the authenticity as we do not believe that Avery Becker really wrote these messages.
I'm going to overrule the 802 and allow the top portion of Exhibit 14 to be admitted. Now let's deal with the body and the text. Counsel for the prosecution, what is your response to the 801 hearsay objection to the substance of the text?
Still under 801T2, this is admission by party opponent.
Any further exceptions?
No, Your Honor.
Are you offering the substance of the text for the truth of the matter?
No, it's going to the effect upon the listener.
All right. Since it's being used for another purpose other than the truth of the matter, I'll permit it to come into evidence. But the trier of fact is instructed that none of the statements can be taken as truth. They can only be taken in consideration as the effect that they had on the witness.
Yes, Your Honor. May Exhibit 14 be published to the jury?
So be published, and it's in the record.
Thank you.
Admitted.
Ms. Cifuentes, did Avery Becker ever say anything to you that really stood out?
Actually, she did.
What did she tell you?
And I quote, she said, well, if he's upset about his car, he's going to be really upset when he sees what I do to his house.
Ms. Cifuentes, do you gain anything by falsifying text messages from Avery Becker?
No, Avery was my best friend.
Do you know why you're here today?
Yes, I'm here today to bring justice to Mr. Brackman's murder.
Were you involved in the investigation at all?
Yes, shortly after his death, I was brought in for questioning by the police.
And did you provide the police with any evidence?
I did. I actually sent him an email of those messages.
And why did you have to send him an email?
On the day of our interview, our questioning, I had not charged my phone previously that night, and I left my phone on the charger, and my dad was rushing me out the door. We were already late, and he didn't want to make me more late. So I left the phone on the charger and just went to the interview, and the detective said it was fine that I had sent in emails.
Ms. Cifuentes, do you still have this phone?
No, I do not.
And do you have anything against Avery Becker?
No, as I previously said, she is my best friend.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. If I could request one moment to stand up and reposition my camera.
Please take your time.
Thank you. Your Honor, before I begin, can you see and hear me all right?
Yes, I can.
Okay, if at any time I cut out, please let me know and I will get that sorted.
If you cut out, I'll do my best to communicate with you. Yes.
Yes, Your Honor.
And if I cut out, we'll just have to do the best we can. All right.
Yes, Your Honor.
All right, please proceed.
Good morning, Ms. Cifuentes.
Good morning.
So from what you saw, Avery Becker always had to put never had to put a lot of effort into mock trial, did she?
No, I would say she put no effort into mock trial.
And you had always tried your best and put in all the effort that you could. Is that correct?
Yes, I reread openings multiple times and closings.
And it irritated you when Miss Becker did not have to put as much work in as you did. Is that correct?
Yes, it irritated the whole team and our coach.
You had a lot of respect for Mr. Brackman. Is that correct?
Yes, he was an amazing team. He was an amazing coach and an amazing teacher.
And you proved your respect through your dedication to mock trial, correct?
Yes.
And you believed Miss Becker never gave Mr. Brackman enough respect. Is that also correct?
She had little to none respect for the team, the coach, and I believe mock trial.
And when Miss Becker got a Best Attorney Award, it felt like a, quote, slap in the face. Is that correct?
Yes, I would say.
And when she had left, you were quite excited for the larger roles that you could have with her gone, weren't you?
Either way, I was going to get a bigger role. Because she's a senior and she was graduating, I was going to get bigger roles anyway. So it didn't really matter that she had got kicked off the team. I was sad, though, that she was kicked off the team.
But is that a yes or no? You were excited that you could pursue mock trial more because of these larger roles?
Yes.
And when Miss Becker had written on the car with permanent marker, you say that she was rightfully demoted to the B team. Is that correct?
Yes.
And with all of the awards in factor and everything that was said on the day of the vandalization of the car, you believed that Mr. Brackman should have pressed criminal charges. Yes or no?
Yes.
So earlier on, you had testified about the text messages. And within those text messages, you had sent them to Detective Markowitz. Is that correct?
Yes, I did send those messages to Detective Markowitz.
And this was 3 months after the murder. Is that correct?
Yes, that would be correct.
I'm sorry. And this is when this is when Detective Markowitz had requested you to bring them in. Is that correct?
Yes.
Thank you, Your Honor. No further questions.
Redirect?
No redirect needed, Your Honor. Thank you.
All right. Next witness for the prosecution.
The prosecution now calls Detective Jordan Markowitz to the stand.
Welcome, Detective.
Your Honor, it appears that I can't turn on my camera. Would the court accept it if I worked off one of my co-counsel's cameras?
Of course.
Of course, thank you. And may I inquire to how much time I have left?
Timer?
You have 16.2 seconds, or 16 minutes and 2 seconds. 20 seconds, my bad.
Counsel, since your name tells us you're Dylan Fairson and you're not, can you, for the purposes of their scoring panel, can you introduce yourself and spell your name so that they can get it correctly?
Of course. My name is Ailey Rubio. ILY, capital RUBIO.
Thank you so much.
No problem.
Ready to proceed with direct examination?
Yes, Your Honor.
Please proceed.
Good morning, Detective. Can you please state your name and spell your last name for the jury?
Morning. My name is Detective Jordan Markowitz, Markowitz.
And where are you currently working, Detective?
I'm currently working with the Denver Police Department.
And how long have you been working with them?
Well, I was a parole officer for 6 years and I've been a detective for 7.
And do you have any certifications that help you as a detective?
Yes, I do. I'm certified in forensic data recovery, cell tower data analysis, and cell phone data recovery.
And what did you learn through these certifications?
Well, I learned how to use things like the Celebrite system, how to use cell tower data to accurately figure out where someone is during a certain point in time, and forensic data helps me in murder cases.
And do you use these certifications often during your detective work?
Yes, I've been through hundreds of homicide cases, and I use all those certifications, almost every single one.
Your Honor, the prosecution now moves to admit Detective Jordan Markowitz as an expert to render opinions in criminal investigation, more specifically homicide investigation, and cell phone data recovery, cell tower data analysis, and forensic data analysis.
Okay, criminal investigation, specifically homicide investigation, cell phone investigation,
Cell phone data recovery,
data recovery,
cell tower data analysis, and forensic data analysis.
response, objection.
Your Honor, I have no objection to the witness's qualifications.
All right. The detective will be recognized by this court as an expert witness in criminal investigation, specifically homicide investigation, cell phone data reconstruction, tower data analysis, forensic data analysis. Did I get that correctly?
I think so, Your Honor.
Okay, then let's proceed.
How are you connected to the Mackenzie Brackman case, Detective?
I was assigned to the case in March of 2020.
And did you ever go to the crime scene?
Of course, I was one of the first responders.
And what did you see upon arriving?
Well, upon showing up, I had found Mr. Brackman's body dead at the front door.
And were there any photos taken of this crime scene?
Yes, there were.
Your Honor, let the record reflect that I have previously shared exhibits 1, 2, and 4 with opposing counsel.
So reflected.
And may I share exhibits 1, 2, and 4 with the witness and bench?
Yes, please.
Detective, do you recognize these photos?
Yes, I do.
And can you give a brief description of what they are?
These would be Mr. Brackman's body as found at the scene of the crime.
And are these true and accurate to the best of your knowledge?
Yes, they are.
Your Honor, the prosecution now moves to admit exhibits 1, 2, and 4 into evidence.
Any objection?
No objection, Your Honor.
So admitted. 1, 2, and 4 are in the record.
Your Honor, may I publish to the jury?
Yes, please.
And did you notice anything else around Mr. Brackman's body?
I did, yes. I located the murder weapon directly next to him.
And were those photos taken of this murder weapon?
Yes, there were.
Your Honor, let the record reflect that I have previously shared exhibit 5 with opposing counsel.
Thank you.
Your Honor, may I share exhibit 5 with the witness and bench?
Yes, please.
Detective, do you recognize this?
Yes, I do.
And what is it?
This would be the murder weapon as found at the scene of the crime.
And is this a true and accurate depiction of what you saw at the crime scene?
It is.
Your Honor, the prosecution now moves to admit exhibit 5 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 5 is admitted.
Now, may I publish to the jury?
Yes, please.
Now, Detective, did you do any further investigation into the house?
I did. I went further into the house and looked about the kitchen and dining room. It looked as if there was a struggle.
What do you mean?
Well, there was a chair knocked over, a broken plate on the floor, and there was a knife drawer ajar.
And were there any photos taken of these observations?
Yes, there were.
Your Honor, please let the record reflect that I have previously shared Exhibit 7 with opposing counsel.
Record reflects.
Your Honor, may I share with the jury?
Has
Or
it?
a witness and the bench, sorry.
Yes, please share with us and then we'll deal with the admission of the exhibit.
Yes, sorry. Do you recognize this, Detective?
I do, yes.
And what is it?
This would be the drawer of knives as found at the scene of the crime.
And is this true and accurate to the best of what you saw at the crime scene?
Yes, it is.
Your Honor, the prosecution now moves to an Exhibit 7 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 7 will be admitted.
Your Honor, may I publish to the jury?
Yes, please.
Now, Detective, did you do any other investigation in the house?
Yes, I did. I recovered Mr. Brackman's phone.
And did you go through it?
I did, yes.
What did you find?
Well, upon going through his emails, I discovered something called mock trial. It actually became a lead point in my case.
Did you further investigate mock trial?
I did, yes, and the students involved.
Did you ever speak to any of the students?
I did. I was able to talk to Alex Cifuentes.
And what did you learn through your talk with Alex Cifuentes?
Well, I had learned that, Alex Cifuentes had pointed me directly in the direction of Avery Becker.
And did you investigate Avery Becker after this?
I did. She's the prime suspect of the case.
Did you ever talk to Avery Becker?
Well, the second I tried to, she lawyered up.
And because you couldn't talk to her, did you do any other investigation into her person?
Well, I immediately became a little suspicious, so I started to do a bit more research, yes, and it turns out that Brackman had a bit of bad blood with Avery Becker.
Did you ever look at her whereabouts on the day of the murder?
I did, yes. I was able to track her exact location using cell tower data on that day.
And did you bring those records here with you today?
I did, yes.
Your Honor, please let the record reflect that I have previously shared Exhibit 15 with opposing counsel.
The record will reflect.
Your Honor, may I share Exhibit 15 with the witness and bench?
Yes, please.
Do you recognize these, Detective?
Yes, I do.
And what is it?
These are the cell tower data. This is cell tower data I recovered on the day of the murder.
And are you the holder of these records?
Yes, I am.
And these are true and accurate to the best of your knowledge?
Correct.
Your Honor, the prosecution now moves to admit Exhibit 15 into evidence.
Any objection?
Yes, Your Honor, I have several objections.
All right.
My first objection is, I'm sorry.
Please go slowly so I can write them down.
Yes, Your Honor. My first objection is hearsay as pursuant to Rule 801, as not only the timestamp, but also the names of Mr. Brackman's location and all of the streets are out-of-court statements being used to prove the truth of the matter asserted.
Response?
Oh, I had more objections, Your Honor.
Let's do one at a time, and then it's easier to for everybody to keep on the issue, especially me because I'm old.
Your Honor, may I respond?
Yes, please.
Pursuant to Rule 801, hearsay is defined as an out-of-court statement being used to prove the truth of the matter asserted. And pursuant to Rule 801D2, admission by a party opponent, these would not be considered hearsay as these are Avery Becker's cell tower data information. The defendant in today's case.
Your Honor, may I respond?
Yes.
The statements of not only Ms. Becker's house and Mr. Brackman's house, but also the timestamp were not made by Ms. Becker. Therefore, they do not fit the exception 801D2 statement of a party opponent.
That is correct.
Your Honor, may I respond?
Do you have any further responses to the hearsay objection?
Yes, Your Honor.
Okay.
This, pursuant to Rule 703, if any evidence that an expert uses in their course of investigation is admissible if they use it in their investigation and it helps the jury further understand the facts of the case.
Any response to the 703 to assist the jury through an expert?
Your Honor, I am pulling up the Rule 703 right now, if you give me just one moment.
Of course.
Your Honor, 703 specifically states that facts or data would otherwise be admissible. The proponent of the opinion may disclose them to the jury only if the probative value in helping the jury evaluate the opinion substantially outweighs the prejudicial effect. This evidence, this takes me directly into my next objection. The probative value of this exhibit does not outweigh the prejudicial effect, as Detective Markowitz has no way of knowing if Miss Becker was in possession of her phone, and this only shows her phone's location, and it is the defense's opinion that Miss Becker was not in possession of her phone. Therefore, this has no probative value, and therefore it is substantially outweighed by the prejudicial effect of this evidence.
All right, well, let's deal with the hearsay objection first. Do you have any further foundation as to the accuracy of this map?
Your Honor, this data is directly from and based off Avery Becker's cell phone, so it is true and accurate to the best of the detective's knowledge and is being used in today's case.
Where did the map come from?
He requested the records from the from the provider that Avery Becker uses.
And is there a stipulation in this competition that all the records are authentic?
I believe so, Your Honor. Let me look. Yes, Your Honor. One of the stipulated facts is that the chain of custody for evidence is not in dispute. Stipulated fact 2.
All right. Very good. Very good round. I'm going to overrule the hearsay objection as this is a authenticated business record from the cell phone company from their data. What is more interesting to me is the 403 objection on probative value versus prejudice. And I'm gonna go ahead and admit it, but I know that the cross-examination on this, based on this, is going to be a very important piece of the case, and I look forward to hearing it. So the exhibit will be admitted.
Yes, Your Honor.
Thank you. Thank you for a great round of objections.
Thank you. Now, Detective, did you do any further analysis of this data?
I did, yes.
And did Did you use it in the course of your investigation?
Of course, yes.
Your Honor, the prosecution, or let the record reflect that I previously shared Exhibit 16 with opposing counsel.
The record will reflect that. I accept a publication for purposes of foundation. And let's get the testimony and see if it can be admitted.
Your Honor, may I share Exhibit 16 with the witness and the bench?
Yes.
Do you recognize this, Detective?
I do, yes.
And what is it?
This would be my analysis of the cell tower data I received.
And you made it?
Correct.
And you are the keeper of this record?
Yes,
And do you use this during your usual course of business?
of course.
And is this true and accurate to the best of your knowledge?
Yes.
Your Honor, the prosecution now moves to admit Exhibit 16.
I anticipate that there will be some substantial and significant objections.
Yes, Your Honor. I would object hearsay, more prejudicial than probative, and relevance. May I explain my objections?
Are they the same as the objections before?
No, Your Honor. They are similar but not the same.
All right, great. Then let's proceed with 403 and then the hearsay objection.
Your Honor, again, I object 403 as the probative value of this is not outweighed by the prejudicial effect because the lines that have been drawn by Detective Markowitz cannot be proven by the cell phone data records. And even if they could, it would still only show where her phone would have been. And it is, again, the defense's opinion that Ms. Becker was not in possession of her phone on March 6th. Therefore, this is not only more prejudicial than probative, but it is not relevant in today's case as it does not help the trier of fact.
Response?
Yes, Your Honor. May I address the relevant evidence or the relevant objection and the 403 objection at the same time, I believe is what I'm hearing.
They kind of go together, yes.
Okay. Your Honor, pursuant to Rule 401, relevant evidence is defined as evidence that proves or disproves the material fact. And pursuant to Rule 402, relevant evidence is admissible. Pursuant to Rule 403, evidence is more prejudicial than probative is not admissible. This evidence is more probative than prejudicial as it is an analysis by the detective in his expert opinion of Mrs. Becker's possible route that day and directly goes to the material fact of whether Ms. Becker was at Mackenzie Brackman's house that day.
Response?
Your Honor, again, this goes back to the fact that Ms. Becker was not in possession of her phone on March 6th. Therefore, this evidence, which only shows that where her phone could have been, is not relevant as it does not prove nor disprove where Ms. Becker was on March 6th. Therefore, it is irrelevant and more prejudicial than probative.
Your Honor, may I respond?
Yes.
Your Honor, while I acknowledge the defense's opinion, it is the prosecution's working theory that Avery Becker did in fact have her phone that day. If the opposing counsel would like to bring this up on cross on this evidence, I will happily let him. But as it is my direct, I believe this is entirely relevant and more probative than prejudicial.
All right. With respect to the 403 objection, the court will overrule it. However, during cross-examination, and the court recognizes that the defense has the power of cross-examination and to show that the defense has the ability through cross-examination to show that the prosecution has not proved its case beyond a reasonable doubt. And only knowing those things would I allow this in. 16 is the 403 401 and 403 objection are overruled. Let's deal with the hearsay objection now.
Your Honor, I argue that the line that Detective Markowitz drew on the map is in fact a statement, and it is an out-of-court statement being used to prove the truth of the matter asserted. The truth of the matter asserted being that that is the route that Ms. Becker could have taken.
Response?
Yes, Your Honor. Pursuant to Rule 703, evidence that would otherwise be inadmissible in the court is admissible under an expert's testimony if they used it in the course of their investigation, and it will further help the jury to understand the facts of this case. This is the detective's analysis of the cell tower data and falls within the scope of his expertise.
So just so I'm clear, the objection is to the yellow line on Exhibit 16, correct?
Not the yellow line, but the dotted blue line.
The dotted blue line, and that was added by the detective?
Yes, Your Honor.
All right. The trier of fact is to understand that the dotted blue line is simply an opinion of this witness, and the jury can disregard the testimony or take it all as true. So the court will overrule the hearsay objection and admit the evidence, Exhibit 16.
Yes, Your Honor.
Thank you.
Your Honor. Now, Detective, what does this information tell you?
Well, this analysis is the path that I am certain Avery took to Brackman's house on March 6th.
And this is your expert opinion?
Correct.
And in your expert opinion, what happened when Avery Becker got to Ms. Mackenzie Brackman's house?
I believe that Avery had broken in with the intention to burglarize, and in either an accident had killed Mr. Brackman.
Thank you, Your Honor. That is all for now.
Cross-examination?
Yes, Your Honor, if you give me one moment to reposition my camera.
You can have 2 or 3 moments. Are you ready?
Yes, Your Honor.
Cross-examination.
Good morning, Detective Markowitz. You just talked all about the conclusions that you came to in your investigation.
My professional opinion, correct.
Now let's talk about the evidence behind these conclusions. There was no DNA evidence found.
We weren't able to recover any.
And there were no eyewitnesses that were found.
Well, there was the neighbor who reported the murder.
But they were not an eyewitness.
They didn't directly see, no.
Now you claim that the Ring video camera is evidence that Ms. Becker broke in.
Objection, Your Honor. Assumes fact, not an evidence.
Your Honor, may I respond?
It's cross-examination, overruled.
Thank you, Your Honor.
You claim that the Ring video camera was evidence that Ms. Becker broke in?
That's not the only evidence, but it is a piece of evidence.
But the suspect in the video was wearing a disguise.
A mask and a black outfit, correct.
And Ms. Becker was not in possession of such a disguise.
I wasn't sure. I was unable to get to her. She lawyered up the second I said anything, which I think is signs of a guilty conscience.
So that's a yes to my question. She wasn't in possession of such a disguise.
I wasn't able to recover anything from her.
And in fact, you didn't even bother looking at her residence, did you?
I wasn't able to.
So that's a yes to my question. You did not look at her residence?
The lawyer would not let me.
Now, finally, the video does not have a timestamp, does it?
No, it does not.
So you have no idea what time the video was taken?
I believe it's the time that Avery Becker had arrived to Mr. Brackman's house, as shown by the cell tower data analysis.
I understand that that is your opinion, but you have no empirical evidence that of when the video was taken.
Not on the video, but everywhere else.
Now, moving on, let's talk about the investigation that led you to the conclusions we just talked about.
Sure.
You claim that the biggest break in your case was talking to Alex Cifuentes?
Correct.
However, you interviewed Avery Becker and Taylor Perkins before you ever spoke to Alex Fuentes.
I wasn't able to interview Avery Becker because, like I said, she immediately lured up. And what was the second thing?
So it is your opinion, it is your testimony in court today that you did not speak to Avery Becker before you interviewed Alex Fuentes?
I wasn't able to. She lured up instantly.
Your Honor, at this time, I ask that my trial technician display Exhibit 17, which has already been admitted.
Please publish 17 to the witness in the trier of fact.
Yes, Your Honor.
Sorry, Your Honor, I have to move closer to see the exhibit itself. Detective Markowitz, right here on the second box, it says Becker, comma, Avery, suspect 1, defendant, correct?
I do believe that's what it says, yes.
And it says interview on June 5th of 2020.
Interview RPT?
Yes.
Yes, it does say that.
And then on this box right below it, it says Fuentes, suspect 2.
Yep.
And it says that the interview was conducted on June 6th.
The attempt at the interview.
Are you saying that you never interviewed Alex Fuentes?
Oh, wait, Alex Fuentes. I'm sorry, I misread that. Yes, correct. I interviewed Alex Fuentes. That's my bad.
Thank you, Mr. Hernandez. You can stop displaying the exhibit. So you did, in fact, interview Miss Becker before Alex Fuentes?
Wasn't able to. I was only able to interview Alex Fuentes.
Now, you received screenshots that you claim were sent by Miss Becker.
Yes.
Objection.
However,
Those shots were sent by Alex Fuentes, not Avery Becker.
Proceed.
Your Honor, I believe opposing counsel simply misunderstood my question. I can rephrase.
Okay, thank you.
You were sent screenshots by Alex Fuentes of texts that were originally supposedly sent by Miss Becker.
You say supposedly as if they weren't sent.
Is that a yes to my question? You received screenshots from Alex Fuentes?
Yes, I did receive screenshots from Alex Fuentes.
However, this was a full 3 months after the crime took place.
Yes.
And you didn't even ask him to bring his phone in to be analyzed?
I thought he would bring his phone in, but I believe, like she said, she had left it charging, so I wasn't able to get a hold of it.
So you only made one attempt to analyze her phone?
The screenshots, I guess you could say that.
So you have no idea if, in fact, these screenshots were altered?
I believe they weren't altered remotely. That's my professional
Yes, I understand that is your opinion, but you have no facts to empirically say that these screenshots were not, in fact, altered.
There's circumstantial evidence. I do not believe that Alex Fuentes had done anything to alter these texts. I do not believe that she is trying to frame Avery Becker.
Detective Markowitz, I believe you misunderstood my question.
Off my witness.
Your Honor, may I respond?
Let's all take a breath and proceed with your questioning.
I understand your opinion is that Mr. Cifuentes did not alter this evidence. However, you have no way of knowing for sure that he didn't, or she didn't, excuse me.
I guess there's like a 0.1% chance in there somewhere.
Now, let's talk about Blair Rollins. You knew that Blair Rollins was a suspect in this case?
For a short amount of time. I didn't really think much of Blair Rollins. I'm 100% certain that Avery Becker was the murderer in this case.
So you never made an attempt to find Blair Rollins?
Not the prime suspect. Avery Becker, all the evidence pointed towards her. I was only focusing on her.
It is your testimony in court that you were only focusing on Ms. Becker?
I was primarily focusing on Avery Becker.
Well, let's talk about Ms. Becker's phone. You claim that because her phone was at Mr. Brackman's home, she must have been there?
Correct.
But you are aware that Ms. Becker lost her phone on March 5th.
I'm aware that is your opinion.
Are you aware that Ms. Becker claims to have lost her phone on March 5th?
I'm also aware that that is her opinion.
And you are also aware that there is no way to know whether or not Ms. Becker had her phone on her?
I am 100% certain that she had her phone on her that day.
I understand that you have a lot of opinions on things, but I'm asking about what the evidence shows. You have no evidence proving that Ms. Becker had her phone on her.
No direct evidence, but circumstantial evidence.
Now, let's talk about why you have no idea if Ms. Becker had her phone on her. You never looked into her alibi?
That is not what I said. I am fairly certain that she had her phone on her that day.
You never looked into her alibi, yes or no?
Never looked into her alibi? I didn't believe she was at the Fry Shack that day, if that's what you're asking.
But you do understand that she claimed to be at the mall and the Fry Shack with Miss Perkins?
I understand that's what she claimed, but I'm certain she's guilty.
But you never looked into this, did you?
No, I wasn't able to. She lawyered up.
You never looked into mall security footage?
I wasn't able to.
We never made any attempt to stop you from looking into mall security footage.
Again, didn't have the time.
You're saying that you did not have the time to make a thorough investigation before you put this girl on trial for murder.
I made an incredibly thorough investigation. I am 100% certain that Avery Becker is the murderer in this case. I'm 100% certain that on March 6th, she had traveled from her own home into Brackman's residence.
Detective
in an attempt to
Markowitz.
burglarize.
Detective
And ended up killing
Markowitz.
Mr. Brackman.
I am not asking about what you believe or what your opinion is. I'm asking about what the evidence actually shows. Did you, yes or no, look at mall security footage?
I wasn't able to.
Did you look at security footage from the Fry Shack?
I wasn't able to.
So you never made any attempt to look into her alibi, yes or no?
Not that specific part of it.
Thank you, Your Honor. No further questions.
Thank you. Anything further?
Yes, may I conduct a redirect, Your Honor?
Yes, please. Proceed.
Detective, why weren't you able to visit Avery Becker's residence?
Well, like I said, she had lawyered up pretty much instantly. I was never able to interview her, and I was never able to go to her home.
And is this also the reason why you weren't able to recover any evidence?
Directly from her house. There's plenty of evidence showing that Avery Becker is in fact the murderer for this case, but I wasn't able to recover anything from her home.
Thank you, Your Honor. That will be all.
May I conduct a brief recross?
Yes.
Detective Markowitz, just so we are clear, you did not search Miss Becker's home.
I was not able to, as I've said multiple times.
So that is a yes, you did not search her phone.
Well, I tracked it.
I'm sorry, her home. You did not search her home.
Oh, her home. That's my bad. I wasn't able to, like I said.
And you did not look into her alibi.
Objection, Your Honor. Asked and answered.
Your Honor, may I respond?
No, it's sustained. It's been asked and answered several times. Anything further?
No, Your Honor.
All right. Anything further from the prosecution?
The prosecution rests, Your Honor.
All right. Will counsel for the defense call the first witness?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
We need the defense. There you are. All right. Are you ready?
My apologies, Your Honor. I had to reposition.
Don't worry about it. Ms. Gonzalez, are you ready? Oh, I'm sorry. It's direct examination of Hayden Clausen, right?
Yes, Your Honor.
All right. Please proceed.
Good morning, Ms. Perkins. Please introduce yourself to the jury.
Good morning. My name is Taylor Perkins, and I am best friends with Avery Becker.
How do you know Ms. Becker?
I was on the mock trial team with Avery.
And how was your experience on the mock trial team overall?
The experience was good at some points, but it wasn't the best. If Coach Brackman didn't like you, you didn't always have a great time.
And how do you think that Ms. Becker did on her performance throughout her seasons of mock trial?
Avery did incredible, but didn't put a lot of effort into mock trial because she didn't need to. She was the best on the team, but even so, Brackman had demoted her to our B team.
And why is that?
A month or so before regionals, Avery had showed up to practice the most unprepared I have ever seen her. And her performance was still flawless, like always. But she even got an award, but Brackman was super furious and moved to the B team.
And what did you think about the demotion?
Avery was the best in there. Senior or not, she deserved to be on A team. She had so many awards to prove it as well.
Moving on, did you and Miss Becker still hang out after you quit the mock trial team?
Of course, she was my best friend.
And did anything happen around the time of Mr. Brackman's murder?
Yes, actually. The day prior, Avery had lost her phone at the Fry Shack.
And what had happened all of that day?
Basically, we had gone to the Fry Shack after school, after Avery had attempted to go to practice. It didn't work out, and we were there for a while. It turned out not to be the best idea to go there, however.
What do you mean?
After a while of being there, some of the mock trial team had showed up, and we had gotten into a discussion about it, and at some point, Alex had joined the conversation and caused Avery to get upset.
And you mentioned Miss Fuentes. Did you two ever communicate in or out of mock trial?
We wouldn't talk if it wasn't necessary.
Would you say that you know Miss Fuentes?
I wouldn't say we were extremely close, but yes, I do know her.
And is it possible that Miss Fuentes stole Miss Becker's phone that evening?
Yes, it is possible because the last time I saw her phone, Alex had it.
And is there anything that happened the next day?
Yeah, we had a carpooling plan, and Avery wasn't responding to any of my texts, and I was trying to figure out if she was picking me up or not. She never responded, so when she showed up, I asked her why she didn't respond, and at that point, we realized, oh shoot, your phone's missing. Where is it? And we went out to search for it.
And where did you search?
We went to the mall and everywhere we had been the day prior, and I was calling and texting her phone and trying to hear something. Sadly, we never did.
And how long did it take you to search for her phone?
We spent the entire day looking for her phone.
And did you ever find it?
No, we did not.
And when you were looking, did you ever go back to the Fry Shack?
Yes, we did. And it was kind of strange.
Why is that?
Well, the mock trial team had showed up, and it was during their practice time.
And do you know of anyone who could have killed Mr. Brackman?
Blair Rollins, actually. It makes a lot of sense.
And who is Blair Rollins?
Blair Rollins was a girl from my high school. I'm not exactly sure where she is today, however.
And where did that idea come from?
Brackman was Blair's father's lawyer in a murder investigation, and when Brackman lost the case, Blair's dad got sent to jail.
And how do you know this?
Everyone in the school knew about Coach Brackman's and Blair's history.
And Miss Perkins, to the best of your knowledge, with all that happened that day, do you believe that Miss Becker killed Mr. Brackman?
No, she couldn't have. We were together the entire day looking for her phone. It's not like she had the time to slip away and murder someone.
Thank you, Your Honor. No further questions.
Cross?
Yes, Your Honor. May I proceed? Ms. Perkins, you and Avery Becker were best friends, correct?
Yes, that is correct.
And in your affidavit, you stated that you would do anything for Avery Becker, correct?
Yes, I have previously stated that, minus risking someone else's life.
And Avery's relationship with Mr. Brackman was no good, yes or no?
Yes, that is correct.
And this was because Avery put no effort into mock trial, correct?
Yes, that is correct, because Avery didn't need to put as much effort as our other teammates.
And Avery never came prepared, correct?
Yes, but she always performed flawlessly, like always.
But Avery didn't try hard enough, yes or no?
Avery tried when it was necessary.
And you would say that Avery was the best attorney?
Because she was, yes, I would say so.
And both you and Avery agreed that Mr. Brackman was a mediocre coach, correct?
Yes, he didn't know how to manage our team properly.
In fact, Avery even played some games on Mr. Brackman, yes or no?
Can you restate your question? What do you mean by games?
I meant to say, in fact, Avery even played some pranks on Mr. Brackman, yes or no?
Yes, that statement is true.
And during the regional tournament, Avery came unprepared, correct?
Yes, but she performed flawlessly and even got an award for her performance.
And Mr. Brackman, as the coach of mock trial, had then demoted her to B team, is that correct?
Yes, that is correct.
So then you proceeded to quit mock trial, correct?
Of course, mock trial meant more to Avery than it did to me anyways, and Avery loved mock trial. I didn't care for it as much as she did.
So you did this because you wanted your best friend, Avery, to be back on A team?
Yes.
And so Mr. Brackman had no choice but to move Avery back up to A team, correct?
Yes, that is correct.
But you were a good attorney too, correct?
Yes, I was, but I was nowhere near as good as Avery.
And Coach Brackman called out Avery on her bad workmanship, is this correct?
Yes, that would be correct.
And Mr. Brackman, as the coach of the mock trial team, knew best about mock trial?
I wouldn't say he knew best, but he knew what the team needed at times.
And Avery wrote on Mr. Brackman's vintage Porsche with a permanent marker, yes or no?
Yes, that is true, but at the time she believed it should not be permanent.
And so Avery wanted to just blow off some steam?
Yes, that's what she wanted to do. She was just angry at Brackman for just demoting her for such a good performance.
So Avery then got kicked off the team, correct?
Yes, that is correct.
And Avery was upset about this?
Of course, who wouldn't be? If you get kicked off something you like, wouldn't you be upset?
So Avery was desperate to be back on the team, is this correct?
Yes, I would say so.
And Avery even went as far as to go to a mock trial practice to beg Mr. Brackman back on the team?
Yes, she did.
And after this, you and Avery went to the Fry Shack, is that correct?
Yes, that is correct, which turned out not to be the greatest idea.
You happened to bump into the mock trial team there, correct?
Yes, we did. Yes.
And Alex Cifuentes was there?
Yes, she was.
And Avery and Alex didn't get along, is this correct?
I mean, on the surface, they were okay, but I wouldn't go out of my way to call them best friends.
Yet Avery even asked Alex for help back on the team. Is this correct?
To the best of my knowledge, she might have.
So Avery texted Alex Cifuentes for help back on the team, correct?
Avery had informed me that she might have, but I'm not certain if she did or not.
So Avery then claimed to have lost her phone at the Fry Shack, correct?
It's not a claim, it's what happened. She lost it when Alex was with it.
And you said this phone was like a third kidney to Avery?
Yes, it was. So if it was out of her reach, she was obviously really, really, really upset.
But it took you all night and even the next morning to realize that her phone was missing?
Yeah, we don't really talk as often as we used to when we were in school.
So you weren't with Avery on March 6th.
I was with Avery on March 6th, just not in the morning.
You don't know where Avery was on March 6th.
No, I don't, but she was probably home more than likely.
Avery broke into Mr. Brackman's house?
No, she was with me the majority of the day. There's no chance.
Avery killed Mr. Brackman?
She couldn't have. She's not that rash. I know Avery can be rash, but she's not rash enough to commit a murder.
And you would do anything for your best friend Avery, so you covered for her, correct?
No, that's not true. We were at the mall.
That is all, Your Honor. Thank you.
Redirect.
May I inquire about a brief time check?
Of course, you have 20 minutes and 25 seconds remaining.
Very brief redirect, Your Honor. Miss Perkins, you and Avery were best friends, is that correct?
Yes, we were.
And you had been around her throughout all of mock trial.
Yes, that is true.
And during any of this time, did she show any signs of anger or manipulation towards you specifically?
No, she was just sad and felt horrible that she was kicked off her favorite activity.
And when you were on the team, Mr. Brackman had made a lot of choices in regards to Avery, is that correct?
Yes, that is correct.
And even though you had seen her performing firsthand, you also believe that Mr. Brackman, made the wrong decision in demoting her. Is that correct?
Of course, senior or not, Avery deserved to be on A team. She was the best we had.
That is all, Your Honor. No further questions.
Does the defense have any further witnesses?
Yes, Your Honor. The defense would like to call Blake Van Owen to the stand.
Please proceed.
Ms. Van Owen, are you ready?
Yes, sir.
Can you please state your name for the jury?
Of course. My name is Professor Blake Van Owen.
And as a professor, what do you teach?
I teach police procedure and criminal justice at CU Denver. Before that, I was a faculty member at Community College of the Rockies.
Do you have any professional experience with police procedure?
Yes, I spent some time in the Aurora Police Department, and after that, I worked as a private investigator. I've testified in court many times to police procedures.
Can you describe specifically what you've testified as before as an expert witness?
Of course. I've testified in criminal justice, police procedures, social justice, cell tower analysis, cell tower data, as well as private investigation.
Your Honor, at this time, I would like to admit Professor Blake Van Owen as an expert in general police practices, including forensic evidence techniques, crime scene reconstruction, and cell tower analysis.
Any objection? Dylan, you're muted.
No, Your Honor.
The witness will be admitted as outlined by counsel
Thank
and
you.
recognized as an expert.
Professor, can you tell us what the prosecution has claimed happened?
Of course. The prosecution claims that Avery Becker broke into Mr. Brackman's house, engaged in a brief struggle with the victim, and ultimately killed him and fled.
Do you believe that this is what occurred?
No, I do not.
How so?
Well, this conclusion was obviously rushed by the experts of the prosecution's case, and had they taken a closer look at the evidence, they would have seen the real answer.
Okay, so what are your own reasons for this case being rushed by the prosecution?
Well, there are 6 main reasons. First, we have the knife block. Second, the scuff marks on the floor. Third, how the knife was held. Fourth, the text messages. Fifth, the cell tower data. And sixth, the lack of other suspects investigated.
Let's go into your first reason, this knife block.
Well, in Exhibit 5, which has been previously admitted, there is a large metal knife covered in blood laying on the ground. This knife doesn't match the rest of the knife sets in the house because those knife sets are half metal and half dark wood. The defense expert, Mr. Cusack, claims that the murder weapon came from the knife block in the kitchen, but that is highly unlikely seeing as they are not a match set.
Your Honor, at this time, I ask that my trial technician display Exhibit 8 for the purposes of identification and display Exhibit 5, which has already been admitted into evidence.
Granted.
Mr. Hernandez, can you please focus on Exhibit 8?
Yes, of course.
Thank you. Ms. Van Owen, do you recognize this exhibit?
Yes, I do. This is a picture of the knife block in Mackenzie Brackman's house.
And is it fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 8 is admitted.
Ms. Van Owen, can you give a more in-depth description to the conclusions that you came to based on these two exhibits?
Of course. As we saw in Exhibit 5, the knife is solid metal. In Exhibit 8, you can see here that the knives are half metal, half wood. Mr. Cusack claims that the murder weapon came from this knife block. However, seeing as they are not a match set, it is highly unlikely that that knife came from this knife block, meaning that the intruder brought the knife with them into the house.
And can you go into your second problem with the prosecution's case?
Of course. My second problem with the case is the scuff marks on the floor.
What's wrong with the scuff marks?
Well, we don't have on them. We don't know when they were made. We don't know how they were made, which means they're unreliable evidence and they can't be used to form a conclusion.
Let's go into this conclusion you're talking about, that there was a struggle. Your Honor, at this time, I move to display Exhibit 4 in that display Exhibit 4, 19, and 21. Exhibit 4 has already been admitted in 19 and 21 for the purposes of identification.
Exhibit 4 has been admitted. Let's publish 19 and 21 for purposes of identification.
Professor, do you recognize these two exhibits?
Yes, I do. Exhibit 19 is the autopsy report, and Exhibit 21 is a photo of my hand holding a knife.
And are these fair and accurate to the best of your knowledge?
Yes, they are.
Your Honor, at this time, I move to admit Exhibits 19 and 21 into evidence.
Any objections to 19 or 21?
No objections, Your Honor.
19 and 21 are admitted.
Professor, let's start with Exhibit 4. Can you please describe this exhibit and your conclusions based on it?
Of course I can. Exhibit 4, you can see that the wound given to Mr. Brackman lies laterally across his chest. This means that the knife would have entered laterally, and that is almost impossible in an over-the-shoulder motion such as Cusack claims, and would also be...
Objection, Your Honor, outside this witness's scope.
Response?
Your Honor, may I ask my opposing counsel to clarify which statement she's objecting to?
I am objecting to the statements about the forensic data pertaining to the wound, as she has not been admitted as an expert in forensic evidence.
Your Honor, Ms. Van Owen has been admitted as an expert in forensic evidence techniques, so this is within her scope of expertise.
I don't remember if that was on the list of areas. Can you briefly lay the foundation so that we can assure ourselves that we've done everything correctly?
Ms. Van Owen, can you please briefly describe your experience with forensic evidence?
Of course. I've investigated many homicides as a private investigator, as well as with my time in the police force. And I worked with forensic evidence in that time.
How long was that?
My time with the police force or my time as a private investigator?
How much time do you have into forensics?
I've spent about 7 to 8 years working crimes like this.
Any further objection to this witness being admitted for forensic as recognized as an expert in forensic evidence?
Yes, Your Honor. This witness has not laid any foundation. The foundation pertaining to education and training to work with forensic evidence is not been admitted. I believe that you should have education and training if you are going to work with dead bodies such as this.
Objection is overruled. The witness will be recognized as an expert in forensic evidence. OJT on the job training is just as good as school for purposes of experts.
Thank you, Your Honor.
Your Honor, may I repeat the question?
Yes, please. Thank you.
Ms. Van Owen, can you please go into your conclusions based on Exhibit 4?
Of course. As you saw in Exhibit 4, the wound given to Mr. Brackman is lateral across the victim's body, which would be very, very hard to deliver such a wound in a bear hug type motion, such as Kuzak claims, and also nearly impossible had the intruder not been much larger than the victim. However, as we have seen in the ring videos, the intruder is relatively small.
Objection, Your Honor, assumes facts not in evidence. The ring videos have not been admitted to the court yet.
Mr. Seidel, do you intend to admit those?
Yes, Your Honor.
I'm based on that offer of proof, we'll proceed. Overruled.
Thank you, Your Honor.
Mr. Hernandez, can you please display the two exhibits of the 2 ring videos for purposes of identification?
Of course, if I could have a moment.
I believe that they are Exhibit 12 and 13. Ms. Van Owen, do you recognize that exhibit?
Yes, I do.
And is it fair and accurate to the best of your knowledge?
Yes.
Your Honor, at this time, I move to admit Exhibit 12 and 13 into evidence.
12 and 13?
I believe that is what my trial technician displayed, so yes.
Any objection?
Yes, Your Honor. The witness, Professor Blake Van Owen, is not the keeper of these records and did not originally obtain these records, so I do not believe that she can speak to them with any degree of expertise.
Counsel for the defense, did your expert review these in order to form their opinion?
Ms. Van Owen, did you review these?
Yes, I did. I reviewed all of the evidence.
Objection overruled.
Thank you, Your Honor.
Ms. Van Owen, before I begin asking questions about this exhibit, did you or did you not, can you tell if there is a certain suspect behind that mask, or do you have any idea?
No, you cannot tell who's wearing the mask. It covers their entire face, and they were wearing gloves.
So you're saying that this exhibit does not have any weight to the actual suspect being identified?
No, it gives a general height of the suspect entering the house, but we do not know the identity of the suspect in any way.
Okay, let's continue with the reconstruction of the stabbing that you're describing. Can you please describe how the height of the victim factors into the stabbing?
Of course. In order to deliver such a deep wound, in order to puncture the top of the heart, which is the victim's cause of death, the attacker must be significantly larger than the victim in order to reach over their shoulder and provide that much force. However, as we saw in the video, the intruder is quite small based on the size of the door.
Now let's go into Exhibit 21. Can you please describe your conclusions from this?
Of course. Exhibit 21 is a photo of my hand holding a knife that I deem most likely for the knife to have been held in order to give the victim the wound.
Can you describe how this idea contradicts that of the prosecution's?
Of course. This type of hold gives the holder of the knife enough force and the position to stab downward into a victim's back and puncture the top of their heart.
Thank you. Now let's go into your fourth problem with the prosecution's case, these text messages.
My fourth problem with the prosecution's case is the text messages, because seeing as they're screenshots, they're pretty much unverifiable. And had Detective Markowitz used the police's technology that he has available to them, we would know how reliable they actually are.
Can you describe this technology?
Of course. The police have a technology called Celebrite, which allows them to download the contents of any phone in order to analyze it. However, Detective Markowitz chose not to use this in this case and simply accepted photos of screenshots that could have been doctored.
Your Honor, at this time I would like to display Exhibit 15, which has previously been admitted into evidence.
Granted.
Ms. Van Ohm, can you describe this exhibit?
Of course. Exhibit 15 is a diagram made by Detective Markowitz to show the general area that the 3 cell towers Avery Becker's phone, or what was Avery Becker's phone, pinged off of.
Can you describe what you think of the accuracy of this exhibit, or if it has any way to verify where Ms. Becker was?
Of course. These towers simply show where a phone connected at a certain point in time. They cannot pinpoint a phone, and they cannot tell you what was in the phone's message. However, they give a general location to where the phone might have been. It could have been anywhere within 7 to 8 miles of each of these towers.
And let's go into your sixth and final problem. You said there was a lack of other suspects in this case.
Yes, I find it very odd that the police did not thoroughly investigate every other lead in this case, specifically the one about Blair Rollins.
Why do you specifically mention Blair Rollins?
Well, Blair Rollins had some trouble with Mr. Brackman, seeing that Mr. Brackman put Blair Rollins' dad in jail. And I believe that this would give Blair Rollins a larger motive to potentially cause harm to Mr. Brackman.
Do you know what happened to Blair Rollins after the crime?
No, Blair Rollins vanished from Colorado after their graduation.
And has the prosecution at all looked into investigating Blair Rollins?
They were made aware of Blair Rollins, but they did not pursue any leads following them.
Thank you, Ms. Van Owen. No further questions at this time.
Counsel for the prosecution?
No. Oh, yes, the prosecution is prepared to cross, Your Honor. Sorry.
Thank you. That's
Good morning, Professor.
Good morning.
You have become disillusioned with the justice system. That is correct.
Yes, I experienced a flaw in it when I left the Aurora Police Department.
And this is because of when you injured a young woman of color during an arrest. This is correct?
Objection, Your Honor. May I be heard?
yes.
This is improper character evidence as well as more prejudicial than probative. This is improper character evidence, as this is a prior past act that occurred 20 years ago that is unrelated to the case, while Ms. Van Owen was working at a different job than she is today.
Response?
Yes, Your Honor. Pursuant to Rule 611, the credibility of the witness is always an issue during a court, and I am laying foundation to attack the credibility of the witness later.
I have a question. Does the line of questioning go to her honesty?
The line of questioning goes to her benefiting from testifying only for the defense. And this contributes to it as to why she only testifies for the defense.
Response, Your Honor.
Certainly.
This does not have any weight to the credibility of Ms. Van Owen, as this was, as I mentioned, a job she was working 20 years ago that is different from her job today. And this job does not have anything to do with her credibility in her current job that she's testifying to today.
Is there linkage to why she only testifies for one side? Because
Yes.
of the situation? Mr. Seidel?
I do not believe there is, because this does not have anything to do with her experience as an expert witness or as a private investigator. This is simply a prior past act that occurred 20 years ago, and she's working an unrelated job.
Under the NETA rules, I will admit this. I will overrule the objection, and you may proceed with your questioning.
Yes, Your Honor. Do you need me to restate the question?
Yes, please, that would be nice.
This is because of when you injured a young woman of color during an arrest, correct?
Yes, the procedure that I was using was approved by the force, but I didn't find that it was nice and there was an injury.
And this is why you only testify as an expert for the defense, is that correct?
No, I'm not sure why this would ever have any reason to why I only testify with the defense. I only testify for the defense because I'm not a public servant.
Thank you. But you only testify for the defense, that is correct.
Yeah, the prosecution has their own experts that they don't have to pay.
Blake Van Owen. And you make $6,000 to $10,000 for every case, that is correct?
For my expertise, yes.
And you make a decent living off of this work.
I make a living of pointing out where the prosecution has dropped the ball, yes.
So you benefit from testifying against the prosecution then, that is correct, Mrs. Blake Van Owen?
I'm not a Mrs., thank you very much, but yes, I do benefit. This is my job.
And in your direct, you referenced Taylor Perkins. She is the only alibi that Avery Becker has in today's case, that is correct?
Not necessarily.
Will you please answer with a yes or no?
I can't. That's impossible for me to answer with a yes or no.
And Avery Becker was marked absent on March 6, 2020.
Yes, Avery was absent on March 6th.
And you didn't obtain any security footage that confirms they were looking for Avery's phone? Yes or no, please?
No, I was not able
Thank
to,
you.
but at the same principle.
And you didn't obtain Taylor Perkins' cell tower records? Yes or no, please?
I'm sorry, I could not hear your question.
And you didn't obtain Taylor Perkins' cell tower records? Yes or no, please?
I did, but they were not accepted as evidence.
And you didn't confirm Taylor Perkins' alibi? Yes or no, please?
I did, actually. They were at the mall looking for Avery Becker's phone.
You don't have any physical evidence that confirms Avery's alibi? Yes or no, please?
I don't have it in court today. It was
Thank you.
not accepted.
And you don't have any physical evidence that confirms Avery was with Taylor Perkins on March 6, 2020? Yes or no,
I've
please?
had it been accepted, but it was not.
You believe that the police came to an easy conclusion?
They did.
And that their evidence shows they didn't really investigate the scene? the
Well,
case?
they would have more evidence if they had actually investigated.
And in your direct, you mentioned that you conducted a partial investigation. To do this investigation, you reviewed the reports and exhibits conducted by the experts on the prosecution. Yes or no, please?
Yes, I did.
And your investigation is purely based on evidence from the prosecution. Yes or no, please?
No, it's not.
Your investigation is purely based on conclusions from the prosecution. Yes or no?
I used their conclusions in my
Thank
investigation.
you.
Objection, Your Honor.
Yes.
Opposing counsel has cut off my witness on multiple occasions, and I would like to ask her to refrain from doing that in the future of this cross-examination.
Your Honor, may I respond?
You have been. So let's just slow down a little bit and let the witness speak.
Yes, Your Honor.
Thank you.
In your direct, you mentioned that you reviewed the Ring video cameras. Is that Ring videos? That is correct.
You cut out for a good second there. I couldn't hear you. I'm so sorry.
Oh, it's okay. I will re-ask the question. In your direct, you mentioned that you reviewed the Ring videos. That is correct.
I did.
And did you prepare an affidavit for today?
I did, yes.
And you signed it?
I did.
And it's accurate to the best of your knowledge?
Yes, it is.
Your Honor, may I screen share Van Owen's affidavit?
Yes.
Read along with me, please, from line 60 to line 63. I have reviewed the police reports, the crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz. Now, you would agree with me that nowhere in there you mentioned the Ring videos?
I reviewed all of the evidence and all of the conclusions made by Kyle and Markowitz.
I asked you a proper yes or no question. You would agree with me that nowhere in that line you stated that you reviewed the Ring videos, yes or no?
They are not mentioned by name. However, in stating that I reviewed all exhibits and all evidence, they are included.
Thank you, Your Honor. That will be all.
Anything further?
Yes, Your Honor, but before I begin, can I ask for a brief time check?
Yes, you have 11 minutes and 55 seconds.
Thank you, Mr. Hernandez.
You're muted.
Sorry. Ms. Van Owen, are you a public servant?
No,
So would you even be allowed to testify as an expert for the prosecution?
if they deign to hire me, I would be able to. However, they have their own public servant experts.
And it was mentioned that you are paid for doing this. Do you do this job for the money, or do you do this job for the justice?
I do this for justice. I don't do this just because I get paid.
And Avery Becker was absent on March 6th, yes?
Yes, she was.
But so was Blair Owens, correct?
Yes.
Thank you, Ms. Becker. No further questions. Oh, thank you, Ms. Van Owen. No further questions.
Anything more for the defense?
No, Your Honor.
Are you ready for closing arguments?
Your Honor, the prosecution answered for the defense, and the defense actually does have a final witness to call.
Oh, I apologize. I don't know what I was thinking.
The defense calls Ms. Avery Becker to the stand. Good morning, Miss. Good morning. Could you please introduce yourself to the jury?
Hello, my name is Avery Becker.
Why are you here today, Miss Becker?
I am here today because I'm being accused of murdering my mock trial coach.
Did you commit this crime?
No, I wouldn't kill him or anyone for that matter. I'm not a killer. I do feel bad though that I won't be able to apologize for the things that I've done.
We'll come back to that in a moment. Could you tell the jury about your experience with the mock trial program?
Yes, last year I was a senior at Colorado High School, and throughout my time competing for mock trial, I realized that it came pretty easy to me, and I didn't have to try as hard as others.
Did Mr. Brackman agree with you?
No, Brackman made it abundantly clear that he did not like my work ethic. He didn't understand that I could go into practice and know exactly what I was going to ask. He hated when I diverted from scripts, and yeah.
How would you describe your relationship with Mr. Brackman?
It was rocky, to say the least of it.
Now, could you tell the jury about the car incident that Ms. Cifuentes mentioned earlier?
Yes. One practice after regionals, we were going over what we did well at regionals. I thought that maybe Brackman would congratulate me on my Best Attorney Award. However, he just got on my case about my award and said that I didn't deserve it.
How did this comment make you feel?
I was crushed. I got so mad that I stormed out in the middle of practice, and when I got outside, I saw his prized possession, his Porsche. What I wrote on his car Worst Attorney Award with what I thought was a dry erase marker.
What happened after that?
After that, Brackman came outside and blew up at me. He was so mad, and then he kicked me off the team.
Now, how did vandalizing Mr. Brackman's car make you feel?
It was one of the worst things I've ever done in my lifetime. I was not thinking of what I was doing in the heat of the moment, and I regret every moment of it.
Did you ever make an attempt to get back on the team after you were kicked off?
Yes, of course I did. The next day, I went down to Brackman's office and I told his secretary that I needed to talk to him. His secretary said that he was too busy and not willing to talk to me. So because of this, I just had to text him and not talk to him in person like I wanted to.
Moving on, where was your phone on March 6th?
On March 6th? I really don't know. I misplaced it, I think.
So where were you on March 6th?
Well, on March 6th, I went over to Taylor's house and we decided to skip school and go look for my phone. We looked all over, the fry shack, the mall, pretty much anywhere we were, but we couldn't find it.
Your Honor, may my trial technician display what has previously been marked as Exhibit 14 for the witness?
Yes.
Ms. Becker, did you send these texts?
No, I never sent any of this. I don't know who's trying to frame me, but these are not my text messages.
Thank you, Mr. Hernandez. You can stop displaying the exhibit now. Were you at Mr. Brackman's home on March 6th of 2020?
No, I don't know where Brackman lives.
And finally, did you kill Mr. Brackman?
No, I would never kill Mr. Brackman or anyone for that matter. No, Brackman and I did not have the best of relationships, and I'm not going to say that we did, but I would never kill him or anyone. I'm not a killer.
Thank you, Ms. Becker. Thank you, Your Honor. I have no further questions.
Cross-examination?
Yes, Your Honor. Ms. Becker, you're the best attorney, correct?
Yes, I was one of the best attorneys.
And you won Best Attorney Award?
Yes, I did.
You understand the law? You understand the law?
Yes.
You understand?
Objection, relevance.
Your Honor, may I respond?
No, overruled.
Allow me to re-ask that question. You understand the law?
Yes, for mock trial, yes.
And you understand it better than most of your friends?
Yes, I do.
You know what the burden of proof is?
Yes, I do.
And you know what an alibi is?
Yes, I do.
And you hated Mackenzie Brackman as your coach, isn't that true?
Yes, Brackman and I never had the best of relationships.
You hated he stole your thunder.
He did. He always was on my case.
And he rewrote your openings?
He rewrote my closings. I always closed.
Your direct examinations?
Yes, he rewrote pretty much anything.
And your cross examinations?
Yes.
And you didn't think he knew what he was doing?
I just thought that I knew what I was doing and I wanted to do it my way.
You like to think on your feet, correct?
Can you re-ask your question?
You like to think on your feet, correct?
Yes, I do.
And you don't like to use a script?
Yes, because I can think on my feet.
And you hated when Brackman made you stick to that script, isn't that true?
Yes, it was quite annoying to me.
And he called you lazy?
He did.
Objection, hearsay.
Your Honor, may I respond?
Your Honor, you are muted.
Please respond.
Your Honor, hearsay is an out-of-court statement being used to prove the truth of the matter asserted, and this isn't going to the truth of the matter asserted. This is going to the effect upon the listener.
The statement is that she's lazy.
That her coach called her lazy, yes.
All right. The trier of fact will take this for the effect on the witness and will not accept the statement for the truth of the matter.
Thank you, Your Honor. Mackenzie Brackman put you on B team, isn't that true?
Yes, unfortunately, Brackman did.
And you convinced your friend to quit?
I didn't convince Taylor to. She did that out of what she wanted to do.
Mr. Brackman had no choice but to put you back on A team, right?
Yes, that is correct.
You received awards at regionals, correct?
I did. I got a Best Attorney Award and Best Closing.
And you think you deserve them, is that correct?
Yes, I did.
Brackman didn't think you deserved them, correct?
No, Brackman did not, but I thought I did.
And he confronted you and told you that, correct?
Yes, Brackman was always on my case.
And you got mad?
Yes, I did get very mad.
Really mad?
I stormed out of practice, so I was quite heated.
And you rode on his Porsche?
Yes, I did, and it was a big mistake.
But this was no accident, correct?
At the time, it was on purpose, but I regret every moment of it.
And you were so mad you wanted to send Brackman a message, correct?
I don't understand your question.
You wanted to send your coach a message.
I still don't understand your question.
We'll move on. When Mackenzie Brackman found out what you did, he kicked you off the team, correct?
Yes, he did.
And you were a senior?
Unfortunately, yes.
This would have been your last chance to go to state?
Yes, and last chance to compete in high school mock trial.
And in your opinion, you deserve to attend the state tournament, correct?
Yes.
I'm sorry, Your Honor. It appears that my witness has cut out. I ask that the time be stopped until this issue is sorted.
Can you hear me?
Yes, would you like me to restate the previous question?
Yes, please do.
In your opinion, you deserve to attend that tournament, correct?
Yes, I was one of the best attorneys on that team.
And you apologized to us? You tried to apologize to Mr. Brackman, true?
I did my best to apologize to him.
And he didn't respond to you?
Unfortunately, no.
And that made you mad.
A little heartbroken.
And you told Alex Cifuentes so.
I never texted Alex Cifuentes.
You told him if I thought what he did to his car was bad, just wait till he sees what I do to his house, correct?
No, I never said that.
And you've been in the courtroom this entire trial?
Yes, I have.
You heard Alex Cifuentes testify?
They might have testified to that, but I never said any of that.
And you skipped school the day Bracken was murdered?
Yes, I did, to look for my phone.
You went to his house?
No, I didn't. I don't know where Brackman lives.
You tried to get in the front door, but it was locked.
No, I don't know where Brackman lives.
You went around to the back of his house?
No, once again, I don't know where Brackman lives.
You opened the door?
No.
You were going to trash his house?
No, I was not, because I don't know where
Alex Cifuentes.
Objection, cutting off my witness.
Sustained.
May my witness continue and finish her answer.
Ms. Becker, are you finished with your answer?
I can repeat my answer. I don't know where Brackman lives, so I don't know how I would be able to do any of that.
You trashed his house?
No, I didn't.
You told Alex Cifuentes you were going to do this?
No, I did not.
He was home?
No.
He surprised you?
I don't know where Brackman lives, so I don't know.
What?
I don't know where Brackman lives.
Objection, cumulative and waste of time to the jury. My witness has already answered this line of questioning several times, and Ms. Fearson is simply trying to get my witness to admit that she was there when in fact she wasn't.
Your Honor, may I respond?
Yes.
My line of questioning has been different every time. The witness is choosing to answer with the same response.
Your Honor, may I respond?
Yes.
My witness is answering to the best of her ability. It is simply that opposing counsel's questions she cannot answer because she was not there, she does not know where Brackman lives, and she did not kill Mr. Brackman.
Well, if I'm going to overrule the objection, but if counsel wants to continue asking these same questions and getting the same answers, that's her prerogative.
Yes, Your Honor.
Ms. Becker, you murdered Mr. Brackman.
No, I did not. I would never kill him or anyone.
And then you ran away.
No, I didn't.
Thank you, Your Honor. No further questions.
Anything further?
Brief redirect, Your Honor. Ms. Becker, were you at Mr. Brackman's home on March 6th?
No, once again, I don't know where Brackman lives.
Did you ever attempt to manipulate Miss Taylor Perkins?
No, I didn't. Taylor did that because she wanted to, not because I wanted her to.
And finally, did you kill Mr. Brackman?
No, I did not kill him.
Thank you, Your Honor. No further questions.
Anything further from the defense?
The defense rests.
All right. Are we ready for closing arguments from the prosecution?
Yes, Your Honor. The prosecution would like to remind the jury and scoring panelists that due to technical difficulties, I am Eiley Rubio and working off of Dylan Person's computer.
Please proceed.
Your Honor, the prosecution also asks that any time at the end be saved for a rebuttal.
Granted.
Your Honor, ladies and gentlemen of the jury, in the words of Juvenal, revenge is always the weak pleasure of a little and narrow mind. The evidence presented to you today and the witnesses' testimonies have proven beyond a reasonable doubt that Avery Becker is guilty. This is the result of their anger that's been developing for years. Today, Avery Becker, the defendant in today's case, is being charged with second-degree burglary of a dwelling, and first-degree murder. What does this mean to you, the jury? This means that Avery Becker intentionally and unlawfully broke into Mackenzie Brackman's home with the intent to vandalize it, and in the process of committing this crime, killed Mackenzie Brackman. Avery Becker had the motive to break into Mackenzie Brackman's home. Avery Becker had just been permanently kicked off the mock trial team and believed that Mackenzie Brackman had ended their mock trial career. They used every resource at their disposal to try and get back on the team, even going to a mock trial practice and trying to confront Mackenzie Brackman there. They even texted Alex Fuentes and pleaded with her to help them. When all of this didn't work, Avery Becker snapped and planned on going to Mackenzie Brackman's home to trash the place. In Exhibit 14, you heard Avery Becker say that she wanted to upset Mackenzie Brackman, and her intentions and plans to go to the home, break in, and trash it. Avery Becker had the means and opportunity to commit this crime. The intruder had previous knowledge of Mackenzie Brackman's home, knowledge that Avery Becker had as a former mock trial member and student. The intruder, Avery Becker, also chose a time of day when Mackenzie Brackman would normally be out of the house. This is also knowledge that Avery had and used. In addition to motive, means, and opportunity, we also have a timeline that fits both the crime and Avery Becker's schedule for the day. We know for a fact that Avery Becker was marked absent on March, and other than Taylor Perkins' word, Avery Becker has no alibi for that day. Taylor Perkins, Avery's best friend, even testified saying that she didn't know where Avery Becker was on March 6th, and earlier in the year, let Avery Becker manipulate her into dropping from the mock trial team. We ask that you doubt their words about Avery's alibi and consider that either they just didn't know or that they are lying. They may be trying to be a good friend, but this is a court case and Mackenzie Brackman is dead. In addition, we also have Detective Markowitz's testimony about Avery's whereabouts from cell tower data. You saw this in Exhibits 15 and 16. Avery Becker is not the sort of person who would let their phone out of their sight. And even if they did, they wouldn't wait an entire day before going to find it. This is shown in both Taylor Perkins saying it is their third kidney and their attachment to the device. It is not a coincidence that Avery Becker has reported their phone missing. This is a deliberate act by Avery Becker to create doubt about their act of revenge. We, the prosecution, have the burden of proof, and we have proven beyond a reasonable doubt that on March 6, 2020, in Denver County, Avery Becker knowingly and unlawfully entered Mackenzie Brackman's dwelling with the objective to commit second-degree burglary and, in the course of action, cause the death of Mackenzie Brackman. As you deliberate, I ask that you remember Avery Becker has experience in the courtroom and criminal law. Avery Becker knows how to manipulate the system. You, as a jury, have the right to believe all, some, or none of a witness's testimony. When the judge reads you the law, they will explain direct evidence and circumstantial evidence are given the same way in a court of law, and both are acceptable. The prosecution asks that as you deliberate, you will apply the law to the facts and deliver a verdict. Avery Becker is guilty of second-degree burglary and first-degree murder. Thank you.
Thank you. Mr. Winton, are you ready to proceed?
Yes, Your Honor. Before I begin, I ask that if at any time you cannot hear or see me, that you stop me so that I may fix the issue. May it please the court. There is no evidence. The prosecution has put a young girl on trial for murder without a single piece of evidence tying her to this crime. They want you to find Avery Becker guilty without meeting their burden. Let's talk about what their burden of proof was. The prosecution had to prove beyond a reasonable doubt that Miss Becker committed second-degree burglary of a dwelling and first-degree murder. Let's break down what these mean. The first count states that Miss Becker unlawfully entered and remained in Mr. Brackman's home. The second count states that while Miss Becker was in Mr. Brackman's home, Mr. Brackman died. They needed to prove both counts beyond a reasonable doubt. Reasonable doubt is such a doubt that would cause reasonable people to hesitate in matters of importance to them. A mere hesitation is all that is required for you to return the verdict of not guilty. And after hearing all the evidence in today's case, you must have much more than just a hesitation. Let's talk about that evidence, or the lack of evidence. You heard all about Detective Markowitz's failed investigation. You heard them talk about how they knew about Miss Becker's alibi, but they chose not to investigate. You heard them testify that there was no DNA, no fingerprints, and no eyewitnesses. So what evidence do they think they have? A video and a cell phone, neither of which can be tied directly to Miss Becker. The video that they claim as evidence only shows a disguised intruder going through the back door of Mr. Brackman's home. Then there was the phone. The prosecution believes that because Miss Becker's phone was at the scene of the crime, she must have been there as well. However, you heard Miss Becker tell you she lost her phone the day before and spent all of March 6th looking for that lost phone. However, Detective Markowitz, yet again, didn't even bother looking into that fact. This is not the end of Detective Markowitz's unfinished investigation, as instead of trying to get Miss Fuentes' phone to examine, Detective Markowitz simply accepted screenshots that he waited 3 months to ask Miss Fuentes to send. Now, let's talk about Kyle Kuzak and their interpretation of the evidence. They claim that after being alerted by his Ring surveillance system, that Mr. Brackman grabbed a kitchen knife, and through the subsequent struggle, the intruder took control of that knife and stabbed Mr. Brackman. They believe they can gain all of that from undateable scuff marks and a broken plate. Now, you also heard Professor Van Owen tell you about what the evidence actually shows. Professor Van Owen explained to you how there is no reliable evidence showing a struggle. She also told you that because Detective Markowitz never thoroughly searched Mr. Brackman's phone, we have no idea if he even had notifications on. After all you have heard today, there is no possible way you can give the verdict of guilty. You cannot be sure beyond a reasonable doubt because the prosecution brought forward no evidence proving Miss Becker was even at Mr. Brackman's house. Because the prosecution failed to meet their burden, you must give the only just verdict, the verdict of not guilty. Thank you.
Anything further from the prosecution?
No, Your Honor, it appears we have run out of time.
All right, thank you for letting me know. Then this completes our mock trial today. Want to congratulate everyone for a job very well done. You're very welcome to come back online with video so we can have a conversation as the scoring judges are doing their work. Great. I find that after so many practices and trials and criticisms that anything I might say to you probably won't make any difference. So what I like to do is listen to anyone who had a breakthrough and an aha moment today, because I saw a few of you have one of those moments. I can see it on your face when it happens. Something, an insight, a new vibe, a new way of telling this story. Anybody want to share anything like that? Ms. Van Owen, Paige?
Well, today I played a little bit more sassy than I normally would. Usually when I play experts, I'm not super snarky. So doing that today was different, and I guess it was effective in some way.
Emily?
No, I wasn't actually raising my hand. Sorry.
Okay, we're just waving. Anyone else had a breakthrough and how they felt about something, or maybe a failure that you really learned from? Because as a trial attorney, I learn more from my failing than I do from my succeeding, and I remember my failures more than my successes. And I always really think about what I could have done better, and use those things as moments to really become better. Did anybody have one of those kinds of moments where you went, ugh, and you'll know you'll do something different in the future?
I actually have something to say now.
Okay, Emily.
I actually realized that during this time around, I was a little more, I had a little more of an attitude while talking. Not intentionally, but just accidentally, I was a little attitude. So next time, I know I should not be so defensive.
You know, the problems are written such that you kind of do get hammered on cross. You know, there's some, as like real lawyers and people, we probably wouldn't have made some of these mistakes. And so it really, hits you when you're getting crossed. And one of the hardest things that I think for participants is not to take it personally, but to stay in the character and just know that they're not you and they made those mistakes. And this is just, we're just doing a practice and getting used to it and staying in that character. I didn't think that either any of the witnesses were snarky or mean or anything like that. I think that you were showing personality and being memorable. So good job. Max, did you have a breakthrough? I thought I saw your aha moment. Let's see if you can tell me what it was.
I'm not sure about any specific moment, but I was like really stressed out before this. And I think now, just throughout the competition, that stress level reduced a lot.
Right, good. Oops. Well, where I thought your breakthrough was in the arguments on the objections. I think that you got your rhythm and you found your feet. So, that's great. And Marcus, you had a breakthrough too that I saw. Do you know what it was?
No, I'm not sure what you're referring to.
I think you exemplified one of the hardest things that it is to be a trial lawyer is realizing you're completely out of control and letting it go. And one of the things you did really well, Marcus, was that you listened to what was going on and you had to actually change your strategy. And that's really hard to do. And as you think back over what you did, maybe you'll think about where that happened. And good job. Because none of us control what that witness says, and you don't need to control. I can't remember Dylan's alter ego.
Eileen.
Aileen. You know what? One of the things was that when you were cross-examining and you'd go, give me your yes or no, and they'd actually give you an answer that you could really mess with a little bit. So sometimes in cross, don't always worry about just getting that yes or no, but really listen to what somebody says, and then make the point of your theory of the case through what they're saying. So you started once you stopped holding on to I've got to get a yes or no, you started listening, and it was like a night and day. So just keep it up. And Dylan, same thing. You know, just remember a dynamic when you're dealing with a child witness here, and your MJ is a pretty soft, sweet, kind person. And so when you encounter your witness, you have to take them as they are. And maybe next time when you cross Becker, they won't be like Ms. Mintz's, but think about how you would just roll with it. And you don't need to force anything with this. I mean, all she wants to do is look good. And if you can think about that, you don't need to, get exactly what you want. You can let her have some movement in there, and then you don't look like you're beating up on a kid. If the kid's, punked out and, has a really bad attitude. I don't know the language that you would use in high school now to describe this, because I'm very old. But you can tell when somebody is not nice. And the jury knows when they're not nice. And the jury will always give you permission to be not nice to a not nice person. But if they're sweet, like MJ, the jury's not going to like you not being really sweet with her. So, and you can get a lot of cross-examined by being sweet with Ms. Becker. She's got a lot of things that she should have looked at that Sharpie. I mean, it's right in her hand. How could she make that mistake? And you can just do it as nice as pie. Like, you had that marker right in your hand. How come you didn't read the label? And you can just be nice. So now that you know the problem so well, all of you, you can start playing with it. And Hayden, you've got such a great, you're so authentic. And that's really, really hard to know who you are and be who you are, and ask questions like you would talk to somebody normally. It's really good. And Julian, yeah, I mean, you were authentic too. I bet that you're, you have a good sense of humor. You're really quick on your feet, and you were being yourself. And Kyle Cusack, you're that way too. You've got that swagger, both of you. And so always be who you are.
Thank you very much.
You're very welcome.
Thank you.
Is that enough for everyone? Or Rosie, I think I judged you last year in Glenwood. You look
Actually, I've only been in mock trial for about 2 weeks.
Oh my goodness. Well, your cross-examination was spot on.
2 weeks,
Spot on. Questions, no, just telling the story with my single fact questions, just great picture painting with sentences, listening, good job. Did I get everybody? Is there anybody who wants any other feedback? Tammy and Elizabeth and Daniel, are you done grading?
This is Tammy. Yeah, I did. I submitted mine.
Daniel
Yes, I've submitted mine.
and Elizabeth?
Yeah, I submitted.
Would you guys like to make some brief comments and something of value for these very nice young people who I can't wait to see in the courtroom?
I took some notes. I have a few things I'd like to say. Overall, I was actually kind of blown away at the level of professionalism everybody showed. A lot of times you see in the courtroom, attorneys, especially in family law, they take their case really personally and they become very adversarial and contentious. And even, there were a couple of interactions where the heat level rose, but you guys maintained your composure, and that was impressive. Second point is you're all very articulate. I appreciated that. And your knowledge and understanding of the rules of evidence was also impressive. That's actually pretty complex. And having been through law school and the class and everything, I still don't completely understand the rules of evidence in a lot of ways.
Yeah.
They don't violate.
The last thing I wanted to mention was how important witnesses are.
Yeah.
All of the witnesses got into the role really well. You understood the facts, you got into character, you dressed for the part, and I think everyone did a great job, and I'm very impressed. It makes me feel good about the future.
Tammy?
Sure. Just so you guys know, I don't know if you know who I am, but I'm an attorney. So my feedback will be based on an attorney in the trial. I do trials all the time. And so, yeah, I would agree with Daniel that you guys did an awesome job. I was really, really impressed. I've never done this before. So I don't know if you know, like, do they get to know who the winner is? When do they know who the winner is?
At the end of the day, I think there's some announcements about that, Tammy. So they'll just have to stay and wait for the surprise.
Sorry, I have a very loud dog. But yeah, I think there were some people that I think were like spot. I mean, the witnesses were like excellent. Hold on one second.
I'll go. I'm taking over for her. She's used to it though. I agree with both Tammy and Mr. Belcastro. You guys did a great job. I had the privilege of doing teen court. I was a judge for teen court for about 10 years out in Fruita. And never ceases to amaze me how wonderful you all are. And I always think, oh crap, I hope you don't become real attorneys and go against us because we're gonna lose. So, thanks so much.
Yeah, and sorry about my dogs. I was just gonna say, I mean, I didn't do any mock trials when I was in law school, and I should have, because my very first day in trial, the judge was like, "Oh my God, you look like a deer, in headlights." It was bad. So you guys were better than me, better than probably maybe I am at 6 years into this. So you guys were really great, and I think some of it is just nervousness. And I mean, I'm in trial all the time, and with Beth, and I'm still nervous a lot of times. So don't ever be upset about that or something. I saw that in a lot of you, and that's just natural, and sometimes maybe that won't ever go away. And sometimes it's dependent on who you're in front of, or, what attorney's on the other side. And, you guys all handled the objections really well, which is good because sometimes that really throws you off. And you guys did a great job.
I agree. Congratulations to all of you. I wish you the very best of luck. And very proud of you. So have a nice, relaxing break. Do you do another round at 1? All right. Well, let's depart away, and good luck to everyone. And thank you so much for doing this work.
Thank you.
Thank you.